Good morning or afternoon, depending on where you are listening from. My name is Francesca Guerrero. I'm a partner in Thompson Hine's international trade practice, and I would like to welcome you to today's webinar. We're going to go ahead and get started promptly because we have so much to cover. I'm joined by my colleague Samir Varma, also a partner in our international trade practice. There's Samir, thank you. I'm also delighted to introduce you to our other panelists for today's webinar. First is Goran Danilović, a senior associate in Bird & Bird's International Trade and Customs Group. He will be talking with us about UK and EU laws. And finally, Daniel Wiedmann, an associated partner in and head of POELLATH Antitrust Law Department in Germany. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours. This presentation is intended for general information of individuals and organizations. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine. The content also should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions, and this is very important, if you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen, or if you move it around, it might be someplace else on your screen. But there are little arrows. You can click on one so the question box opens and type in a question in the question box. We will try to answer as many questions as we can, both during the presentation, and then we'll circle back at the end of the webinar. If we don't get to your question, we will follow up after the program by email or phone. Also, in the handout panel, another one of those little triangles you can click on, you will see bios of today's speakers. Again, thank you for your interest, and we will get started. First, let me say that during this presentation, our focus will be on giving you first a high-level overview of the current sanctions from these regimes targeting Russia relevant to the Ukraine-Russia crisis. We cannot possibly detail all of them like in specificity. We would sit there and read them, and the US would take up an hour. So we're going to give you a high-level overview of the types of sanctions. Then what we would really like you to come away from this webinar with is an understanding of how to issue, spot, and identify potential issues, kind of start thinking through problems. So we're going to work through a few scenarios, talk about the questions to raise and some of the answers. And we're also going to talk about the enforcement developments and sort of a forecast for what we see next 6 months to a year. So getting started, Samir, I will turn it over to you for our high-level overview of U.S. sanctions on Russia.
Sure, and thanks, Francesca. And I'm really looking forward to our discussion, really hearing from our colleagues in the EU and elsewhere in the UK, just to understand more what's going on there as well. But I mean, from a U.S. perspective, obviously a lot has happened over the past year. I mean, I think it's pretty surprising to think that it's been over a year since this, the war started and the Russia sanctions went into effect. I think at the beginning, most of us on the trade side really thought the war would last a few weeks or months. There would be some sort of annexation of a disputed territory, or alleged annexation, I should say, of a disputed territory that would allow Putin to somehow claim victory or something along those lines. But I mean, I think as the months or weeks or months progressed, we realized this was not going away. And I think the sanctions that were put in place, similarly, or even more so, not only did it not go away, but they started becoming more nuanced and more specific and almost more difficult to sort of understand. And it's, it really has impacted the ability on US companies to do business in the region. I would say that, it's not a comprehensive sanction, right? It's not a sanction on all of Russia and all activity in Russia and all US persons' activity in Russia. It really is something that you have to do you have to understand a lot of how the supply chain, the complexity and the moving parts, and you can do business. And obviously we understand that numerous companies have left, or suspended operations indefinitely. But while it is difficult to do business, there are companies who have stayed, there are companies who are still continuing to do business. And so what I think I wanted to do, is, I think you're right to say that if we went into the specifics of each of these sanctions regimes, I'd be sitting here talking for the entire hour, or Goran would talk for the entire hour, or Dana would talk for the entire hour. So I think what I'm going to do is, like you said, I'm going to do a high-level overview. Try not to get into the weeds too much. If I do get into the weeds too much, please stop me. But at the outset, I think a lot of the restrictions, we can put them into a number of different categories. The first category I would say is the financial restrictions. Obviously, I think that's where it's been hit the hardest, where numerous entities and individuals and oligarchs, or whatever you want to refer to them, have been placed on OFAC, especially designated nationals list, a lot of banks and financial institutions. And I think the reasons why those individuals or entities have been placed on those lists is basically because the US government has said that those persons or entities are complicit in this, and the actions that are threatening Ukrainian sovereignty. They're in various sectors. They're in financial services sectors, energy sectors, metals, mining, arms, their relationship to the Russian government in question, et cetera. I think for US companies who are doing business in the region, most of it really has to do with the banks and financial institutions. OFAC, when they listed the banks and financial institutions on the SDN list, they tried to list a number of subsidiaries as well. But I think what we need to realize is that OFAC obviously has this 50% owned or controlled rule, which basically means any entity that is controlled 50% or more in the aggregate by multiple companies by an SDN, or numerous SDNs, are themselves controlled or subject to the sanctions. And so even though you may see a bank, or you may be doing business with a bank in the region, if they're even if they're not listed per se, you kind of have to do your due diligence and see who the ownership and control is to see whether they're owned or controlled by an entity that is listed. There's a number of different financial restrictions that are in place. Again, I'm not going to go into the weeds there, but that's something, anytime you're doing business there, screening the different entities against those lists becomes important.
I would briefly comment there that those of us who've been dealing with Russia since 2014 remember when we would pay close attention to some of these more nuanced financial restrictions, but in terms of impact, they've been superseded by these SDN, these blocking designations. So, the fact that you can't deal in debt or equity of a certain bank is generally not relevant, although occasionally that will be the only sanction applicable.
Yeah, no, that's absolutely right. And I think that anytime you're dealing with any of these banks, you have to sort of look at why they were placed on these lists. What are they actually subject to? Are they subject to those sectoral sanctions alone that were put in place in 2014? Or are they subject to more restrictive, or maybe, probably more restrictive sanctions more recently in the past year? I think that's sort of, that's an overview of the major sort of issue when it comes to financial restrictions. There are a number of other restrictions, on imports. Imports from Russia are basically, this has been in place for about a year now, they're not subject to the most favored nation, or MFN status, which means they're not subject to the same tariff rules or tariff reduction rules as most other countries. So U.S. importers are paying higher in tariffs, higher in duties for those goods than sort of the other countries that you're importing from. There's also certain bans on importation of certain goods, Russian origin products. Those products are oil, petroleum, natural gas, coal, and coal products. I think even recently there was some more in the sort of fish and seafood, alcohol, etc. And maybe I think there's also gold and diamonds are also restricted imports for importing to the United States. In terms of exports, so I think as many of you know, exports of products from the United States, they're subject to the Export Administration Regulations, and the Export Administration Regulations has a list of products that are controlled for for certain purposes or certain reasons. And so, originally the way this list works is that if you are controlled for a certain reason, you'd have to try to understand if that reason for control impacts your ability to export to a certain country. Now, basically, any items that are on that commerce control list are subject to licensing requirements, and really it's under a policy of denial, so you likely won't be able to get a license. There's a ban on export of all luxury goods. There's a ban on the use of sort of US dollar denominated banknotes with certain Russian banks. I think one of the areas, obviously, that people have been interested in is the sort of ban on services and what kind of services you can provide in Russia. The original list included accounting, trust and corporate formation, management consulting services, and most recently, just at the 1 year mark, they added some additional ones, which included some computing services, quantum computing services, and other related services.
Samir, I want to be mindful of time, but I'd actually also like to ask you to talk a little bit about the export lists of EAR 99 items that are in industrial, oil and gas. They're pretty lengthy lists. Some of the struggles companies have had in just identifying when they have something on that list.
Sure, yeah, and so the U.S. has basically used a number of different methods and what's interesting is this is sort of where different export control areas are now sort of getting combined, so not only do you have to look at your EAR list, but you also have to look at whether or not there are products that have certain Schedule B numbers that are subject to those lists as well. So it's not just, you're absolutely right, Francesca, it's not just the commerce control list, but there's other lists that are being used to identify products that are subject to these export control restrictions. There's also you need to be mindful of the foreign direct product rule, which again could be its own half-hour section today, but really it's the idea that there are products that are made from U.S. technology outside of the United States that could have restrictions on the ability to export those products into Russia as well. I think I'll stop there, being mindful of time, unless, Francesca, you want me to talk about anything else related to the U.S. sanctions, just the overview right now.
We can circle back to some key points when we're talking about our scenarios, I think. Daniel, I'd like to turn to you to sort of tee up what's happening from the EU perspective. And I will say, as a U.S. lawyer, it's been an interesting experience dealing with Russia and being in a situation where the EU is often more restrictive. I'm not used to being in that situation.
Yes, I mean, I think you can say that in many areas, sanctions are broadly similar because, I mean, obviously they have been discussed and broadly agreed within the G7 group. But yeah, there are many differences. I mean, in the EU, the sanctions need to be agreed by the member states, yeah, which makes it a very political exercise because, I mean, there are different views among member states how strict sanctions should be. We now had the 10th round of sanctions, yeah, and it's gotten very complex. Yeah, many areas are covered. I mean, basically we have 2 regulations, but which have hundreds of pages of annexes. And will just try to give you a very broad overview, basically following Samir's outline. Financial side, we have the SWIFT ban that prevents certain Russian banks from making or receiving international payments using SWIFTs. Important to note that several Russian banks are also SDNS, or the EU equivalent. They are listed entities, so they fall under the prohibition of providing them funds, yeah, and their assets must be frozen. The European Union has prohibited transactions with certain banks, like the Russian Development Bank, completely. Their prohibition to accept certain deposits from Russian nationals or entities in the EU There's also a prohibition to provide crypto services, yeah, to close that loophole. And there is a prohibition of trust arrangement. For instance, EU nationals may not become trustees in Russian schemes. That's the broad overview on the financial sanction side. Imports, I mean, the EU claims that they have applied import prohibitions amounting to import volumes of around 91 billion euros. Yeah, most importantly, crude oil and certain refined products, with certain exceptions for certain pipeline imports to Poland, for instance. On coal and other solid fuels, steel has been, I mean, there have been important steel imports prior to the sanctions from their significant Russian steel companies, as you know. Then luxury products, gold, jewelry, seafood, liquor, vodka, and so on. On the export side, I mean, the EU claims to have prohibited export with a value of around 44 billion. That relates, of course, to weapons and dual-use goods. There are exceptions, but my experience is that in the dual-use area, exemptions are not granted, at least not by German authorities. Certain types of machinery and transportation equipment, cars, goods for the oil refining industry, and energy industry equipment, aviation and space industry goods, maritime navigation goods, luxury goods, and so on. Yeah, so that's a very long list, and that covers a lot of things. On the SD&S side, yeah, freezing, blocking, I think there are now around 1,500 individuals covered, and plus 205 organizations. That starts with politicians like Vladimir Putin, also includes certain oligarchs close to Putin, their companies, as I said, banking and financial institutions, company in the military sectors. I mean, a trend in the EU that there are a lot of lawsuits against such designations, sometimes also successful. But I mean, what the EU does now, it basically renews the list every 6 months, and if someone successfully litigates themselves from off the list, they would be replaced after on the list again after renewal of the list. It's similar to the US. There's also an indirect prohibition to provide funds indirectly. So, I mean, if a person is on a list, I mean, there's an assumption that the prohibition also applies the prohibition also applies to entities controlled by that person, and there's a presumption that 50% plus owned companies are controlled by such person. Yeah. Interestingly, I mean, there's a bit of a dispute among member states if two different SDNs hold together the majority, is whether this presumption applies to or not. Germany, I think that it says no, but other member states take a different approach. The European Commission does as well. But it's important to know that primarily sanctions are enforced in the EU at the national level.
Daniel,
we have a lot of, yes.
Can I ask a quick question about that? From a practical point of view, if one EU member state has a conservative interpretation, let's say, and if there's two designated parties, they're like that company's designated, and another member state's more permissive. What do you see any scenarios where companies are saying, okay, we're going to rely on the more permissive interpretation? Or are companies just saying, okay, if an EU member state is going to say no, we're just going to take the no approach? Are there some scenarios where that difference is meaningful from a practical point of view?
Yes, I think, for instance, as regards these assumptions, I mean, I've come across scenarios where companies are majority owned by two different SDNs, yeah, and that becomes very significant. What approach your member state or the member state you're present in takes. Yeah, I mean, ultimately, I mean, these questions may be resolved by reference for a primary ruling by the European Court of Justice. Maybe, maybe not. Yeah, so far it hasn't. Yeah, and there, I mean, the interesting thing there are many areas where there are diverging approaches. Yeah. And for instance, I mean, each authority has issued FAQs. Yeah, the European Union has one. For Germany, the German Ministry of Economic Affairs has one. And sometimes these FAQs contradict themselves. I mean, these are only a few points where they contradict. I mean, I would say 95% of all points they are aligned, but there are these points, and that's interesting to note. Yeah, and I mean, you need to really look where is your client present, and sometimes, of course, it's advisable or very advisable to take the more conservative, the stricter approach if you fall under the jurisdiction of several member states, for instance.
Thank you.
Daniel, sorry, Francesca, if I can ask a quick question. Daniel, you mentioned the sort of the ownership, owned and controlled rule that is different. It seems, which is different than the U.S. version, right? The U.S. version is 50% owner controlled in the aggregate. You know, if you have multiple SDNs that own a certain entity and their aggregate ownership is over 50%, then that subsidiary is considered an SDN as well. In the EU and sort of the member states, that can be construed differently, right?
Yes, it can. I mean, I think that the European Commission, I mean, with respect to the provision to provide funds, it says, I mean, there is a presumption, yeah, that can hardly be rebutted, yeah. For instance, I mean, in the area of funds, yeah, in Germany you have two different authorities. For assets, you have an agency, and for funds, it's the German Federal Bank. I mean, they took a very broad interpretation, however, in a specific context, because they had a Russian subsidiary, a banking subsidiary in Germany, and they didn't want to treat it too harshly because they were afraid of a sort of bank run. Yeah, but yeah, these are interesting areas. Yeah.
Thanks. Sorry, don't mean to slow you down.
No, that's fine. Appreciate that. Yeah, I mean, then there are also sector prohibitions very broadly in the area of transport. Yeah, I mean, I think Russian operators are basically shut off from ports, airports, and streets in the EU. Yeah, and I think the last point I wanted to note, I mean, there are also quite significant services prohibitions for EU nationals. Yeah, for instance, prohibition to provide legal services to Russian entities. Yeah, I mean, Russian individuals are exempted here or do not fall under that prohibition. I mean, similar prohibitions apply to accounting, auditing, bookkeeping, tax consulting, and so on. Yeah. And also that Russian entities are banned from taking part in tenders in the EU. And I mean, the complication here is that even EU companies may be banned if they have Russian subcontractors or even source input from Russian companies. Yeah. So I mean, imagine, I mean, you're regularly participating here in tenders, yeah, and you just have a few inputs you need from Russia, then this ban could apply. Yeah.
Interesting. So should we ask Goran now to tell us about the UK and highlight some of the differences in particular?
Yeah, sure. And thanks, Francesca. And I'm really glad to be able to join this webinar and then share also, take your thoughts and also share my thoughts. So I will try to keep it concise and clear and just focus on some differences, let's say, between the EU and the UK. And maybe for the UK, luckily they have left the EU and now they don't have to take care of those, let's say, 27 different flavors that they still have in the EU, and the UK can have its own flavor, which kind of tends towards the US flavor lately. I would have to say, if you look at the enforcement actions, but also in the manner how UK is, let's say, building and setting up its own sanctions framework. Just to name one of the biggest differences between the EU and the UK is that the UK also, like the US, also has general licenses which apply in practice, and the EU does not. Maybe some other points that we have touched upon, maybe a general remark before that. In general, the UK sanctions framework against Russia, it follows kind of the same restrictive measures as the EU, but there are some differences. If we would just look at the, let's say, financial sanctions and at the listings, we can even see there the differences between the different, let's say, sanctioned banks in Russia. Just to take an example, I think also in the US, this bank, MTS Bank in Dubai, was recently designated and sanctioned. Why? Because I believe they got a license in Dubai in view of being able to process payments, and apparently they are key to the processing of Russian funds and transfers and so on. So they were placed as an SDN in the US, and the UK did the same, basically. Why? Because what we see also lately from an EU and the UK perspective is also from a financial services, from a financial sanctions perspective, is that they are trying to focus on parties which are, let's say, facilitators or intermediaries in view of the current, let's say, sanctions in place. So they are trying to focus on those parties and pull them in, and also restrict them and block them in any manner as they can. And you can see that from both the EU and the UK in their legislative frameworks, they have built up, let's say, in the previous sanctions packages, easy ways to list entities and individuals on the listings. Also, entities and individuals who are facilitating, basically, or facilitating circumvention of UK sanctions and EU sanctions. If I look at the whole, with regard to the trade sanctions between the UK and the EU, I would say the EU has now a little bit of a broader, let's say, scope of trade sanctions. The UK is still lacking behind. They are intending to impose, let's say, a new round of export and import related restrictions. They have also not imposed, let's say, a new sanctions package since December 2022, while the EU has already acted upon with the 10th package, and I think the 11th package is also coming its way. If we focus then on the services, which you also touched upon, there is also a difference between the UK and the EU. To start with our own services, the legal services in the EU are prohibited with regard to Russian entities and for the government of Russia, while in the UK that's still not the case. There are also some differences there with regard to the definitions and the scope of services, how they define the different services, which is really interesting to see in practice, where you can come to a conclusion based on the EU sanctions, it's a go, and based on the UK sanctions, it's a no-go. Which makes certain cases really interesting in practice. And I think the latest development from the services point of view in the UK side of things is that they have now also sanctioned, let's say, the asset freeze individuals and entities under the trust services ban. So it was used to be the case that the trust services ban had its own list of, let's say, designated persons, but now they have kind of brought in the whole asset freeze, let's say, sanctions list of individuals and entities under the trust services. And there is also, of course, a general license for the wind down of trust services for designated entities and individuals. Another point that you touched upon is the ownership and control. There again, there is a difference between the UK and the EU, especially with regard to the control criterion, where the UK has a very broad definition, where it says basically affairs being conducted by an entity or person which is conducted in accordance with the designated person's wishes. So please, go ahead and fill in that in practice. So it's a case-by-case approach. They, of course, also refer to the control criteria as set by the EU, but that's in no way, let's say, legally binding guidance when it comes to your own assessment with regard to control. This is also something that has been lately seen as a let's say as a problem in the UK sanctions regime. That's why also the UK updated its recent, let's say, enforcement and penalties guidance, where they did provide some additional guidance, not so much with regard to the control criterion, but with regard to, let's say, the level of due diligence that you are supposed to do in practice.
I will say that that's an interesting issue that comes up often, because the U.S. general rule is really strictly based around ownership and aggregation of ownership. And so the idea that someone might effectively have control with 10% is not something we typically look at. There are a few regimes where that's the test. Yeah. So I do find myself often having to refer, because I have no idea how, obviously I can't opine on what the UK authorities might consider control. So it's a very relevant day-to-day question for due diligence.
Yeah. And one other point that you both touched upon, Daniel and Samir, is the aggregation of ownership. And the UK says, in principle, no, unless there is evidence that there's like a joint agreement between the relevant DPs in practice, and then of course you can do the plus work. I think one last point that I would like to touch upon, compared to the EU, we can see an emerging, let's say, court cases in the UK. We can also see published judgments, for example, with regard to contractual obligations. We have seen recently a judgment with regard to the leasing of aircrafts, which is very important, of course, touch upon a lot of UK activity there. Also on selling of entities in Russia, basically divestments, being authorized by the UK judge in the UK. So hopefully also in the EU we will see an increase, let's say, in judgments and more clarity with regard to certain, let's say, definitions and scope of prohibitions going forward.
That is sort of an excellent transition to what I'd like to talk about next is some scenarios and kind of issue spotting. And the first one I'd like to ask you all about is companies that are winding down operations in Russia, considering pursuing a formal exit through liquidation or sale if possible. If we could talk about what they need, like, the mental checklist of what's permissible, keeping in the background the fact that there's also going to be Russian law, right? And so, there's going to be restrictions on what they can do from a Russian legal perspective, but from a US, UK, EU perspective, what can they do? And you mentioned like this judicial authority. That's very interesting to me, because obviously in the US, typically we would seek a license from the regulator if we needed to do something that was prohibited. But if you could, maybe you could start, Goran, and then we can chime in with thinking through the wind down.
Yeah, sure. As I mentioned, there's been already some, let's say, some court cases in the UK as well, where let's say the selling of a gold mine basically was permitted by the UK judge at the end of the day. But of course, it's a case-by-case assessment and analysis that you need to make. There is, of course, the option under the UK sanctions regime to apply for a license for such divestment. So that's available. That's something that can be done. Also, with regard to the EU sanctions, I think the latest package of the EU sanctions also introduced the possibility to apply for an authorization with regard to, let's say, the divestment and the prohibitions which correlate to such divestments. Let's say the sale of dual-use goods, which are basically located in Russia and so on. So that's what we see now in practice, because there was a lot of confusion, of course, from different parties how to handle this and in practice, and that's what you see now, that specific licenses have been, licensing options have been introduced to enable such divestment.
And just to be clear, to piggyback on what you said, it's not that there's a ban on selling your assets in Russia. It's that there are bans on selling particular assets because of export controls, or there might be a restriction on selling with a particular party, and that's why we need these authorizations.
Or there might be a restriction on receiving the money you receive from the transfer of asset, and there are these exemptions. But important to keep in mind that many of them are time limited. Yeah, for instance, some are limited; they only can be granted until the end of the year. So for certain scenarios, there's really time is ticking. I mean, what I would like to add, I mean, if we are looking at German companies with subsidiaries in Russia, I mean, I think task one is always to take out EU nationals who work in that subsidiary. Yeah, I mean, because they are really in a hard place because, I mean, if you have a subsidiary in Russia, I mean, the EU sanctions regime does not apply per se to that subsidiary, but it would apply to any EU national, a national of EU member state working at that subsidiary, and they can really become, yeah, I mean, the one side they're confronted with EU sanctions, on the other side they're confronted with Russian law, so that's usually task one for us.
You know,
I think, talk about some of the considerations?
I think, you know, a lot of this, so a lot of the ability of U.S. companies to sort of wind down operations was really difficult, you know, early on in the process when companies were leaving Russia and trying to figure out how to leave Russia. I think interactions with financial institutions, you know, Russian financial institutions was, you know, the most difficult aspect of that from a U.S. perspective. And also, you know, some of the wind down periods that were in effect originally have all sort of since passed. And so the companies that are still operating there that are trying to wind down or trying to exit Russia, and I know, you know, we're not, it's really about the Russia law restrictions, right? You know, whether you can terminate your operations, you know, how do you get capital sort of, or tangible assets out of Russia, if you, you know, if you're not, you know, who you're selling it to in Russia, whether or not it's a Russian government entity. You know, there's the employment issues. Obviously, Russia has a major interest in and there's been cases involving companies who are, you know, are they providing enough severance packages? Are they, you know, how do you actually, you know, exit the country and leave all your employees there and leave your employees in a good situation? And I think there's other, you know, there's other sort of Russian related issues like blocking statutes that are sort of moving their ways through the Russian legal system and trying to, in terms of, you know, can Russian companies comply with U.S. sanctions? There's a whole host of Russian issues.
Yeah.
That a lot of U.S. companies who are still, if the U.S. companies are still operating there, you know, what they would have to consider when they consider winding down.
And one that then touches on U.S. sanctions, I'm interested to hear about EU, is I know that there have been some requirements to essentially make a payment if you're liquidating and exiting Russia. So it's sort of an exit payment the Russian government is requiring for certain scenarios. And OFAC issued guidance that said it doesn't fall under the general license that allows like payments to the central bank for sort of day-to-day business operations. So like this is not routine business operations. So when you're in an exit and wind down scenario, it's important to keep in mind that you're no longer like caring about your day-to-day business. And so you may not have authorizations for various payments that are going to be asked or required to complete your transaction.
Yeah, that's absolutely right. I mean, I think it comes back to just the fact that when you're exiting or when you're doing some of these, you know, major transactions, it's often the case where you're going to have to get a specific license from OFAC, and it's similar to a specific authorization from OFAC in order to conduct the transaction.
And I am going to encourage people, if they have questions, to please put it in the question box. I've got a couple of technical questions that have come in, but if you have substantive questions, please type them in there while we're talking. And then I'd actually like to talk about next, and maybe Goran, I'm sorry, not Goran, Daniel, I'll ask you to start because we had discussed this when we were preparing. Some of the sectors where there's actually active continued business between the EU and Russia, potentially because of dependence on that sector, difficulties in finding alternative sources, and I'd like to talk about natural resources and energy a little bit, about what you see there and what companies who are operating in that sector have to think through when they're looking at a transaction.
Very good question, and it really depends on the situations. I mean, if we talk about now from imports from Russia, I mean, there's scenario one that you still have a Russian subsidiary. I mean, and there's what I said before. I mean, take out members of EU member states working at that subsidiary, yeah. So to shield them from EU sanctions. And then, yeah, look. I mean, you really need to look step by step where the trade and the money flow is to make sure it's compliant. Yeah. I think that's a very abstract level, but I think, I mean, otherwise I would probably go too much into details.
I have a question.
Maybe one remark to make there as well, Francesca. But I think you should look out for this with regard to all prohibitions in the EU sanctions regime. There's always this wind down, let's say, provision with regard to contracts that have been concluded prior to the prohibition entering into force. I would say we just discussed flavors between the different EU member states. Please do be aware that different EU member states consider have different interpretations of what the contract is. So if you have like a master agreement or anything like that, or a purchase order, some EU member states might say, okay, but this is a contract, but the other EU member states might say, no, we don't consider this a contract, so you're not allowed to perform any further transactions and supplies.
Thank you, Goran. And we have a question. I'm going to kind of tease it out into two parts. One is talking about oil in particular and the oil cap. If you have an EU owner of non-EU companies, EU owner of foreign subsidiaries who are trading in Russian oil above the price cap, do you see the EU parents being potentially subject to, I guess, being obligated to comply with sanctions, or secondary sanctions are mentioned? But I think first I'd like to ask, like, is the EU parent going to potentially face penalties if they have foreign subsidiaries who are trading in oil above?
I can take that, if I may. Yeah. I mean, you can. I mean, there are several aspects you need to look at here. I mean, the foreign subsidiary is not subject to the jurisdiction. Yeah, it falls outside the scope of application. I mean, if you have, again, EU nationals working at that subsidiary, they are subject to the jurisdiction. Now, if the EU parent is involved in that and knowingly or even incites such a scheme, I mean, that may be seen as a contravention. I mean, at least that's my experience from the German enforcement landscape. But Goran, maybe you have additional or different views.
I would just like to mention, at least I totally agree with the EU approach. Although there also I see some EU member states, they are trying always in such scenarios to look for any EU nexus, because if you look at the jurisdictional provision, which it says any business done in whole or in part in the EU, and it's not further defined, and there's no other guidance with regard to this specific, let's say, a wording that's in the EU sanctions regime. So some EU member states, some EU member states try to, let's say, expand the jurisdictional scope. What we have not seen in the past, for example, with regard to Iran sanctions or North Korea sanctions or Venezuela or anything like that. But the same thing is happening also in the UK, where even UK guidance is saying if there's any UK nexus, we will pull it in and treat it as having UK jurisdiction and try to enforce UK penalties, of course.
I think that's a good case.
There's also this tendency, I think, lately. I think Daniel can also please fill in. I think even the EU member states are thinking about extraterritorial jurisdiction like the US has in place. The UK is doing the same, and perhaps it will come. I'm not sure. Daniel, what are your thoughts about that?
I totally subscribe to that. I mean, sanction enforcement has a bit of a dormant activity in the EU, and that is changing, and there is a very strong political will that this is changing. I mean, in Germany, I mean, they've taken that out from the local prosecutors and built up a special unit just and told them, be sharp, shoot, please shoot. I think that's correct, and you see that first signs of extraterritorial enforcement, something different to the US, the EU always shied away from, also in other areas. So yeah, I mean, if you have something with interference with the price cap, should be very careful.
Yeah, thank you. That's great. I'm keeping an eye on our clock, and so I'd like to transition to a different scenario and ask Samir maybe to start us off talking about companies that might have subsidiaries in Russia that are not winding down, but are essentially operating independent of the parent. And this goes to the scope of jurisdiction we were just talking about with the price cap. What's going on with subsidiaries of US or other companies operating in Russia?
Yeah, no, thanks. And it's a good segue from the prior question, simply because of this idea of extraterritorial jurisdiction and secondary sanctions. Obviously, the US right now doesn't have a secondary sanction regime in place for subsidiaries of US companies, right? Non-US subsidiaries of US companies doing business in Russia. Unlike sort of some of the other sanctions regimes like Iran and North Korea and whatnot. So yeah, there is no secondary sanction issue, meaning non-US subsidiaries of US companies can continue to do business in Russia. And they have continued to do business in Russia. I think there's a lot of, initially there's a lot of difficulty in making sure that there is no US jurisdiction. I think everyone sort of knows that the US enforcement agencies, if I can put it mildly, I guess, it likes to assert itself all over the world and create jurisdiction over entities outside the US. And so there's, you have to be careful in terms of setting up your operations and making sure that everything really is walled off from US persons, US dollar transactions. The money flow you need to make sure that the money flow isn't directly coming from the United States, that there's no, it really is walling it off and setting up a system where the U.S. companies aren't involved in the day-to-day operations or significant operations of the company. And so that has been, we have been working with a number of companies who've continued to do that and who can continue to do business. I wouldn't say it's necessarily specific to any industry. I think it's maybe a lot of consumer goods, a lot of non-high tech areas that are continuing to do business, but it can be done for sure.
Goran or Daniel, do either of you want to comment on what you've seen as concerns for companies that are in this situation or have subsidiaries in this situation?
Yeah, I think from my side, I think the most important aspect that we have seen in practice is, okay, we are going to leave the Russian subsidiary as it is. It's going to do make its own decisions and so on. But the question then pops up: how far can we support it from IT-wise? I don't know, administration for the salaries of the employees, you name it, ERP system, SAP, things like that. They're like these daily-to-daily engaged software systems, and let's say the guidance let's say the support being provided by the EU entities in practice, or I don't know, a simple IT ticket that's being made by an employee in Russia saying like, I don't know, my Teams or Zoom doesn't work. So those have been the questions that we have come across, also in view, of course, of the services ban, which has been imposed by the EU and as well as the UK, and of course the exemptions there that apply. For example, the exemption for EU mother companies for their subsidiaries in Russia, where such services are for their exclusive use. So for the exclusive use of the Russian subsidiary, and not so much for the Russian subsidiary passing it on or transferring it to, let's say, to the Russian customer, then it's fine, basically.
I mean,
those have been the questions that we have seen, and of course, I would say the software platforms and so on. Those are the more complex questions out there that we have seen, how to handle those and how to perform compliance in relation to such services and activities.
Yeah, maybe just to add one sentence, and I fully agree to what has been said. I mean, just the broad picture. I think what we see in Germany and there are a lot of German companies with subsidiaries in Russia, and I mean, I think there's three groups. I mean, if the subsidiaries are even sanctioned or acting in an area that is sanctioned, then it's almost impossible to keep doing business. And these are the companies that are winding down their operations in Russia. Then they're on the other side, so the areas that are not sanctioned at all, yeah, for instance, medical devices. And there it's really, I would say, yes, you need to be careful about certain things, but it's absolutely possible. And then there are these very challenging ones in the middle. Yeah, and there I see a tendency that increasingly companies are shutting such subsidiaries down too.
Thanks. No, this is really helpful. I'd like to talk about enforcement developments next, but we do have a question maybe we can weave in, which is, are there sanctions against well, countries that are continuing to do business with Russia, but also I think we should talk about companies from other countries that are not US, EU, UK, who are continuing to do business with Russia. What are some of the sort of risks for a violation or potentially being sanctioned that you've seen? If we can talk about both that and then, well, actually, let's just start there. We'll start there and then we'll move to enforcement. Samir, if you want to talk about that a little bit to briefly kick us off.
Sure. And I think the question, I mean, if we're talking specifically about countries themselves, then, I think the answer is no, right? There aren't prohibitions against, specific countries. And even just in the past month, there have been a number of entities in other countries that have been placed on the SDN list. And become specially designated nationals, right? Because of their activity in Russia and because of their nexus to Russia and Russian, entities. So there certainly are restrictions being placed on other companies and non-US companies outside of Russia, but there haven't been countrywide prohibitions.
Yeah.
Goran, do you want to talk a little bit about what you think the higher risk activities are for third country companies?
I agree with Samir. The tendency that we have seen, especially now with the latest, let's say, package, just one company to highlight, for example, Sun Ship Management Limited in Dubai based. It's part of this Russian company, PEO Sovcomflot. It has been placed on the EU asset freeze list. Why? Because it was found to be facilitating and circumventing the sanctions. So what we're seeing now, and I think with the 11 package, we will see even more companies in third countries. I'm just mentioning a few, I think, which are of concern, maybe Turkey, Kazakhstan, and so on. Maybe Daniel can tell you some more, where certain companies will definitely be listed.
Yeah, no, I mean, that's an interesting area. And I mean, I just have here a paper of proposals by the German Ministry of Economics to combat circumventions. And what they think, okay, first they want to stricten the rules for German companies. So basically they are proposing, it's a proposal yet, that for every sanctioned good, a German company needs to have an end-use certificate. Yeah, and violation of that end-use certificate could become criminally sanctioned. They want to increase pressure on third countries by, let's talk about tariffs. Yeah, what's your, I mean, that's of course a diplomatic measure, and as Samir mentioned, they want to frequently use the possibility to put companies in third countries on the SDN list, yeah, if they take part in circumvention schemes, and maybe even exclude such companies or even states from sanctioned goods. And that's of course the most far-reaching proposal, and I don't think it's a realistic one, but that's the current thinking. Yeah.
It's very interesting that they're even talking about that. I want to make sure we talk about enforcement before the end of the hour. We have a couple more questions. I'm going to hold them. I know we can all, like the speakers can stay an extra 10, 15 minutes if we need to answer questions. But I'd like to ask you, Daniel, to talk about EU criminal sanctions developments.
Yes, I mean, first of all, it's important to note, I mean, that there are no EU sanctions. I mean, sanctions regimes are entirely at the national level. And at the moment, I mean, it's a very mixed picture. I mean, that in some, I mean, it goes from imprisonment of up to 12 years just to monetary fines. And I mean, in Germany, for instance, I mean, you have the maximum for individuals, it's imprisonment of up to 5 years. For companies, there may be monetary fines of 10 million, and there may be also fines for management for not having an appropriate compliance system in place. Yeah? I mean, what the EU is now proposing a certain harmonization of these rules, and I think that would also aim for an imprisonment of up to 5 years. And appropriate monetary sanctions for companies, which may also include disbarment from public tenders and so on. Yeah.
Quick clarifying question. You said that the EU is considering requiring an end-use certificate for all sanctioned products. They don't have that in place yet.
That Germany is considering that.
Germany is considering. Sorry, I know. Yes, I am using the umbrella term. Germany is.
That would be national regulation, legislation. Yeah.
And it's not yet in force. Okay, thank you. Goran, do you want to add anything about the EU enforcement priorities?
No, I totally agree with Daniel. When it comes to the EU enforcement, it's a spaghetti bowl, I would have to say. So as Daniel mentioned before, it's up to you to ensure, okay, with which EU jurisdiction am I dealing with, and then zoom in into the enforcement and penalties framework in that relevant EU member states. We know that some EU member states, let's say, are not that let's say strong in enforcement. Others are much more out there, having a proactive approach. The same as the UK. Maybe this is a bridge to the UK. The UK has basically invested in the last 2 years in building up the enforcement unit, as well as the let's say the different departments. When it comes to the implementation, administration, and enforcement of financial sanctions and trade sanctions, because there are different departments dealing with different, let's say, type of sanctions. What we see also in practice when it comes to the interpretation, when we talk with, let's say, the UK officials, when it comes to the interpretation of sanctions, they take a very broad approach, which is something that they have not done before, I would say, again, compared, let's say, to the Iran sanctions and so on. The same goes for the jurisdictional scope. There's like, you can see that there's a sense and an approach of expanding the jurisdictional scope, also when it comes to the enforcement of penalties. So they are taking a more proactive approach. So they have invested. There are more people. They are out there doing also audits. We see more and more also cases coming up in the UK So the UK is kind of also taking a, well, let's say the US flavor. So they're really looking at what the US is doing, and are more and more focusing on taking the US approach rather than the EU approach. Maybe that's also one of the reasons why they left the EU.
Samir, would you like to talk to us about what's happening with US task forces and then enforcement?
Sure. I mean, it's certainly enforcement has been ramped up, and even there's the joint task forces that have been, they've been actually issuing sort of press releases related to certain cases involving Russian invasion, simply to sort of make U.S. companies aware of how much evasion is occurring. And in fact, earlier, I think this month, the Departments of Commerce, Justice, and Treasury issued a joint note sort of noting all the evasion on Russian sanctions and basically cautioning, multinational companies to be, they use a lot of strong language, like to be vigilant against, against the companies that are trying to evade sanctions and export control laws, and the unprecedented scope and scale of sanctions, and sort of all the different actors that are trying to circumvent that by using third parties to circumvent all the different restrictions and disguising payments and whatnot. And so certainly it's on the minds of the U.S. government, and they really are trying to make everyone aware that enforcement has ramped up, and there are a number of cases right now in the works against companies that are trying to evade the sanctions.
Thank you, Samir, and thank you, Goran and Daniel. I think this has been great. I can't believe how much we've been able to cover quickly in an hour. It is the top of the hour. I know some people will drop off. I would like us to stay for a few minutes and talk about some of the questions that we've received, if that's fine. One goes to this vigilance idea, and there's a question about, for items that you can export into Russia, they're permitted items, what is sort of a best practice for due diligence about, I'd say first, making sure that the customer is not a restricted customer. And then the bigger question, which was actually asked, is if you are working with a distributor, what sort of a reasonable amount of diligence to prevent your distributor from reselling the products to a prohibited party? What's sort of the expectation there? Samir, maybe you can start a bit with that one, unless someone else wants to jump in.
No, I can jump in there. First, I think this is an issue that comes up all the time. And it goes back to my comment just now about the note from the enforcement agencies about evasion and use of third-party distributors and agents. One issue obviously is that companies, distributors and agents and distributors in the region often don't want to provide, customer information to the sellers simply because that's sort of, that's their job, right? Their job is to sell the product, and they don't want you to cut out the middleman. And so it does become quite difficult. I think, obviously diligence, doing as much diligence as you can on all the parties that you can have access to and information to is the most important. I think there are distributors and agents who understand that this sanctions area is fraught with issues and problems, and that they are more willing now to give information related to the end users and end customers and all the banking relationships. Obviously, Daniel touched upon the end use certifications. End use certifications are great, and it's a great compliance tactic, compliance mechanism to have in place. It isn't sort of the end all be all. In other areas of U.S. International trade law, there's been comments. I'm specifically thinking about the FCPA space, but there's been comments from the DOJ and from the government about how end-use certifications aren't enough. Like it's almost like a baseline requirement that you should have that in place if you're concerned about any sort of transactions, but it's not the only thing. But that is a good. We like to use them because it also puts the agents and distributors on notice, right, of all the different restrictions and all the different laws, and stating that, hey, like, you need to do your diligence and understand that these companies aren't on any sanctions lists. I think, and I think it comes down to sort of the interaction between you and your distributor, and how much, how many, red flags can you really get rid of, and how much can you know about the whole entire supply chain, or the entire transaction.
I mean, in addition, what you could add, I mean, if it's a really sensitive product, you would seek for, or should seek for, contractual protection, and ask them to comply with sanctions, and so on. I mean, what lesson learned here is, I mean, if you're dealing with certain, in particular, Russian distributors, that you have to be careful about jurisdiction and venue. Yeah, then ideally the venue shouldn't be in Russia, because there the courts don't care. I mean, there's this famous Siemens gas turbine case where Siemens made everything right. Yes, and they said, okay, no, the turbine must not go to Crimea. Of course, it ended up there. It came to a Russian court, and they said, we don't really care about EU sanctions. So, I mean, arbitration or something like that may be the better choice. Yeah.
And sort of on the front end, just some of the really practical steps, Goran, like for people who might not be doing this day to day, what does it mean due diligence?
Yeah, there's one important aspect that we have seen as a pitfall for many clients, which is basically just looking at the item, especially with regard to the trade sanctions, especially when you're looking through the list of commodity codes and you're saying, oh, this is my commodity code. I think the first question should be, is your item correctly classified under that commodity code? And who has classified it? Was that somebody who has expertise in the customs classification of such an item? Usually the feedback that we get back is, I Googled it, and this is the commodity code that comes up pretty often, let's say in Google. Google can be right, but it's not always right, I would say. So I think the first question is, and that's where also your transaction can be good to go or not good to go, is just checking the validity of the commodity code. Also taking into account that commodity codes are being amended every year and are being, let's say, changed, even in the US, EU, and the UK. Those commodity codes do change. And I think the second point that Daniel was talking about, contractual clauses, what we see in practice is also even like a contractual clauses incorporating audit rights, like even in-person audit rights, to go there and check the specific transactions and to see for themselves that everything has gone, let's say, in compliance with the sanctions regimes.
And actually, that touches on something we got a follow-up question. When companies have distributors in a high-risk jurisdiction like Russia, do you think it's typically a good practice to audit their sales? Like look at who they've sold it to and confirm that in fact they haven't intentionally or inadvertently sold to restricted parties.
I mean, it certainly is, but it's and it's sort of like it's a great audit rights, in contractual provisions are always important to have. It does become difficult because it's distributors are often hesitant to provide all of that type of information. They're obviously it's different if it's an agent, but I think the way you convince distributors. I mean, this obviously this area, Russia is a very difficult area for U.S. persons to do business in, and it's and everywhere else, but it's this idea of like a principal agency theory that the U.S. government, really believes that these distributors are acting on the principal's behalf, acting on the U.S. person's behalf, and so any of the sort of violations that the distributor is potentially doing can be construed back to the U.S. person. And I think getting those audit rights are important if you can get sort of sales data, and it's a great thing to do, but it is difficult.
It really goes to your risk appetite. I think Russia's pretty high risk right now. Yeah. The risk tolerance of companies is much lower in terms of how they manage their distributors. So I think I do see more, considerably more attention paid to reviewing this issue. I'd like to briefly go back to one more question if we have time, which was about services. And specifically, the question was about US, that we got was about, from the US perspective, what services are prohibited. But I'd like to broaden it and talk about the EU as well, and kind of highlight some of these EU-UK differences. Samir, if you could kind of recap the types of services that are prohibited.
Sure. Yeah, I mean, I think so. Just really quickly, the U.S. issued originally they said, the list of services will be provided at a later time, and so those lists have been updated. Originally, it was accounting, trust and corporate formation, and management consulting services. Recently, I think just in the past few months, there was additional computing services, quantum computing services that were added. It's not, and I think that the thing to note is that is not the end. I mean, they can add services at any time. That was sort of the idea, and they just did add some more services just in the past month.
Sure. Daniel or Goran, do you want to highlight some of those differences?
Yeah, I think the only difference that I highlighted just at the beginning is that the UK does not have, like, let's say, the broad scope of services as the EU does momentarily, for example, with regard to legal services and so on. And there is a difference, of course, between the different interpretation between the services. But if you just look at the list the list is almost similar between the EU and the UK. It's auditing, advertising, architectural, engineering, IT consultancy, trust services, accounting, business and management services, public relations services, IT consultancy, as I just said, and of course legal services from the EU. And of course there are certain exemptions and certain wind down provisions with regard to, let's say, ancillary contracts and contracts that have been concluded before the entry into force of the prohibitions.
And do all of these jurisdictions include either an exception or a license for setting aside quantum computing? I'd have to look at this one myself, but the other ones for your subsidiary, let's say you have a US company with a subsidiary in Russia, do they all include a exception for like IT consulting services for your subsidiary? If you don't want to be put on the spot, we can just generally say many of them do. We'd have to confirm their particular service. But is that a fair statement that most of them include a exception for the subsidiary of a company in Russia?
I would say in principle, yes. Only from the UK side, it's not, the exceptions are not already stated in the legislation, so you need to apply a license for it. So that's the difference between the EU and the UK. In the EU, it's already, let's say, exempted. You don't need to apply for a license. And then in the UK, you need to apply for a license. And I think there's one comment that I would like to make, general comment that I would like to make. Please watch out for your supply chain. Your supply chain, because Russia is now blocked, I think the shipments are going different these days. We just came across a case where actually nobody was notified, but the Chinese sellers happened to find a more efficient route, which was through Iran. A transshipment via Iran or any other sanctioned countries from China to, let's say, Europe or customers in let's say in the nearby countries. So I would say please watch out and try to update your knowledge about this actual supply chain, how the goods are coming into the eventual destination. I think this is important not just for the buyers, but also for any financial institutions in between or any service providers in between intermediaries facilitating such transactions.
An excellent point. Yes, I have seen people trying to get products legitimately eligible for export to Russia having tremendous difficulty considering options for transit that raise FCPA or AML or other risk factors. So yes, consider that. I think I'd like to give everyone a chance for a last comment. This has been a great discussion. And as we mentioned on the intro, we will send you everyone who's still here, you will get a recording of this. I will also mention that we have a blog, thompson-hine-smarttrade.com. Encourage you to go there and subscribe. And then Daniel, any last comments before we sign off?
You caught me on the wrong foot here. No, I really don't. I think we, as we stated, I mean, the tendency in the EU is more enforcement, and also for US companies that have operations in the EU or that come across in the EU. I mean, that's important to note.
Right. Goran, anything? I know you just made a last comment about
yeah, maybe 2 points, and it relates also to the enforcement. What we see is multi-jurisdictional enforcement approach, especially there's this enhanced partnership between the US and the UK. They're sharing information, so be aware of that. And I think the second one, which is also important, as a director or management or board members, please be aware, at least in the EU and the UK, that there is personal liability as well.
Thank you very much. And Samir, you can take us home.
Okay, no, I think that just one item is, in terms of enforcement, I think that the US government in every sort of area of international trade loves to use sort of the willful blindness theories. And so, the idea of not turning a blind eye to any transaction. So, doing the diligence, documenting the diligence so that if ever there is an issue, you can point to sort of what you did and how you cleared the transaction internally can be very important. And I think that's it. And lastly, I guess thank you, Francesca, for hosting and doing such a great job. Really appreciate it.
You are welcome. Thank you to all of our listeners, and you will hear from us within a couple of days. Bye.
Thank you.
Bye.
Bye.
Bye.